Question 41. The Criminal Procedure Code provides for either no appeal or only one appeal against an order of conviction. Elucidate. So first we have to see whether this statement is correct or not. How many appeals are available in case an accused is convicted? This statement says that there is either one appeal or no appeal. So first we will see the relevant provisions. Appeal against convictions is provided in section 374. Let's see the section first. 374 has many subsections. First subsection, trial by, where the trial is held by a high court. So in every case of conviction where the trial is held by a high court, the accused or the convict has a right to appeal to the Supreme Court under subsection 1. So yes, this is one appeal he is having. Where the trial court is a court of session, then the accused or the convict can file an appeal to the High Court. Yes. And the third provision is, this provision is in two parts, where the trial is held by a magistrate's court. Now here, the appellate court will depend upon the quantum of punishment. The trial is held by a magistrate's court and the punishment is more than 7 years, then appeal shall lie to the High Court. Now, in what situations a magistrate's court can give a punishment of more than 7 years? Because the limit of a magistrate is 7 years, so how can it be more than 7 years? Under section 29, a chief judicial magistrate is empowered to give a punishment of imprisonment of up to 7 years only. Any other judicial magistrate can give punishment of up to 3 years only. And a judicial magistrate of second class, of course, can give punishment only up to 1 year. So when will that situation be? When a magistrate can give punishment of more than 7 years? Anybody?
Section 30 aggregates 14 years. The CJM can give.
Yes, you are right, Smita, but it's section 31. Small mistake. Okay, so under section 31, a magistrate can give a sentence of more than 7 years in case of multiple offences in a single trial. Multiple offences in a single trial, and where the punishment is to be borne consecutively. If it is concurrent, then it can't be more than 7 years. If it is consecutive, then it can be more than 7 years in case of a chief judicial magistrate. And the maximum there is 14 years. So yes, in that case, so this provision is referring to a conviction on a trial held by a chief judicial magistrate where the accused is convicted of multiple offences in a single trial. And then the remaining cases where the punishment is up to 7 years, the appeal shall lie to the Court of Session. So 374 is providing for appeal against conviction, and this is one appeal. Now there are exceptions to this general provision of 374. 375 says that there shall be no appeal where conviction is made on the basis of a plea of guilt. In all such cases, there will be no appeal. As far as conviction is concerned, appeal can be made on the quantum of punishment which has been awarded. So this is one exception. And we have one more exception in 376 which says that there shall be no appeal in petty cases. So we can now make a statement that there is either one appeal against a conviction or there is no appeal against a conviction. If the conviction is in respect of a petty offense, there will be no appeal. If the conviction is based on a plea of guilt by the accused, then also there shall be no appeal. But in all other cases, one appeal is provided. Is there any other provision which provides for appeals against convictions other than 374? Is there any other provision in CRPC which provides for appeal against convictions?
378.
There is one more section, and that section is 379. So we move on to 379. Appeal against convictions. Now here we are dealing not with the trial court, we are dealing with the appellate court.
High Court.
Under 374, we were dealing with the trial court. Where the trial court is the High Court, appeal lies to the Supreme Court. Where the trial court is the Session Court, appeal lies to the High Court, etc. In 379, we are dealing with an appellate court, and here the appellate court is the High Court. If there was an order of acquittal by a lower court, appeal has come to the High Court, and in appeal, the High Court reverses the order of acquittal and punishes the accused with death sentence or life imprisonment or imprisonment exceeding 10 years, then an appeal shall lie to the Supreme Court. This appeal is a matter of right. Under section 379, the convict has a right to go to the Supreme Court in appeal in every such case. But if the imprisonment is up to 10 years, then he cannot go in appeal. So now what is the situation? When there was an acquittal by a lower court, the matter has come to the High Court convicts the accused for the first time with a punishment of up to 10 years, then he has no appeal. So here is also another situation where there is not a single appeal against the conviction. This is the first time the accused has been convicted by the High Court, and there is no appeal against such conviction. So we can say that this is one more situation where there is not a single appeal against conviction. And one more situation which has not been considered anywhere by the CRPC is where there is acquittal by a magistrate's court, appeal comes to the Sessions Court, and if the Court of Session convicts him, reversing the order of acquittal, then where will he go in appeal? Again, there is no provision providing for an appeal when conviction is made for the first time by a Court of Session and there was acquittal by a magistrate's court. So we can say that there are many situations where no appeal is available against an order of conviction. So that statement which was given, the question is correct, and we have to mention all these sections starting with 374, then 375, 376 and 379.